In Chapter 35, we're going to talk about third persons in agency. The breakdown of the chapter is what is the liability among and between principals, agents, and third parties with respect to contracts. What is the liability of principals, agents, and third parties under varying degrees of agent's authority and principal's disclosure of identity or existence? And what is the liability of the principal for the torts and crimes of the agent? If an agent makes a contract with a third person on behalf of a disclosed principal and has proper authority to do so, and if the contract is properly executed, the agent has no personal liability on the contract. If a person makes a contract as an agent for another but lacks the authority to do so, the contract does not bind the principal. If the agent's act causes loss to the third person, that third person may generally hold the agent liable. When neither the act of the agency nor the identity of the principal is disclosed, the third person is making the contract with the agent, and the agent is a party to the contract. When the agent makes known the identity of the principal and the fact that the agent is acting on behalf of the principal, the agent is not a party to and is not bound by the contract that is made. When the agent makes known the existence of a principal, but not the principal's identity, the third person is making the contract with the agent, and the agent is therefore a party to the contract. This is a partially disclosed principal. An agent is liable for his or her own torts. A principal may also be liable for an agent's torts if they result from the following: the principal's own tortious conduct or the principal's authorization of a tortious act. Additionally, if the agent is an employee whose conduct the principal employer controls, the employer may be liable for negligent or intentional torts committed by the employee. Most intentional torts that employees commit have no relation to their employment. Thus, the employer would not be liable under the common law. The modern law holds that the employer is liable for an intentional tort committed for the purpose of furthering the employer's business. An employer who knows or should know that an employee has a propensity for committing tortious acts is liable for the employee's acts. Under the doctrine of respondent superior, the principal employer is liable for any harm caused to a third person by an agent employee within the scope of employment. The doctrine imposes vicarious liability on the employer, which is liability without regard to personal fault of the employer for the torts committed by the employee in the course of the scope of employment. Courts will consider the following in determining whether a particular act occurred within the scope of employment: whether the employee's act was authorized by the employer, the time, place, and purpose of the act, whether the act was one commonly performed by employees on behalf of their employers. Courts will consider also the extent to which the employer's interest was advanced by the act, the extent to which the private interest of the employee was involved, and whether the employer furnished the means or instrumentality by which injury was inflicted. Courts will finally consider whether the employer had reason to know that the employee would perform the act in question and whether the employee had done it before. Negligent hiring retention. Negligent hiring theory, unlike respondent superior, is based on the negligence of the employer in the hiring process. The hiring of an individual with a criminal record does not by itself establish the tort of negligent hiring. The negligent retention theory, on the other hand, exists when the employer knew or should have known that the employee would create an undue risk of harm to others in carrying out job responsibilities. Negligent supervision and training holds the principal directly liable for its negligence in regard to training and supervision of its employees and agents. The modern decisions hold that the employer liable for fraudulent acts or misrepresentations of the employee. The rule is commonly applied to the principal-agent relationship. An agent is liable for his or her own crimes. A principal employer is not liable for an agent's or an employee's crime simply because the agent or the employee committed the crime while otherwise acting within the scope or authority of employment. If work is done by an independent contractor rather than an employee, the owner is not liable for harm caused by the contractor to the third person or their property. Also, owners are not bound by contracts made by independent contractors. The owner is ordinarily not liable for harm caused to third persons by the negligence of the employees of the independent contractor. When a third person makes payments to an authorized agent, the payment is deemed made to the principal. A principal is bound by a statement made by an agent while transacting business within the scope of employment. The principal is bound by the knowledge or notice of any fact that is acquired by an agent while acting within the scope of actual or apparent authority.